Section 14.2. Arbitration. 1. What is arbitration? A. A public court trial where the government appoints a judge. B. A private litigation process where parties set the rules and choose an arbitrator. C. A negotiation process where both parties must settle without a third party. D. A government-mandated dispute resolution process. Answer. B. A private litigation process where parties set the rules and choose an arbitrator. 2. Who is an arbitrator? A. A government official who supervises negotiations. B. A lawyer who represents one of the disputing parties. C. A private judge chosen by the disputing parties to resolve the conflict. D. A mediator who helps both sides reach a voluntary agreement. Answer. C. A private judge chosen by the disputing parties to resolve the conflict. 3. What is one of the main advantages of arbitration according to ADR proponents? A. It is always less expensive and faster than litigation. B. It is always required by law before going to court. C. It is usually less expensive and quicker than litigation, but not always. D. It allows disputes to be settled without any costs. Answer. C. It is usually less expensive and quicker than litigation, but not always. 4. In which types of disputes is arbitration best suited? A. Cases where the parties want a highly publicized trial. B. Disputes between parties who have an ongoing business relationship and want confidentiality. C. Disputes where one party has no interest in resolving the issue quickly. D. Situations where one party wants to punish the other publicly. Answer. B. Disputes between parties who have an ongoing business relationship and want confidentiality. 5. What is a potential drawback of arbitration? A. It is always more expensive than litigation. B. It cannot be used for business disputes. C. If one party prolongs the dispute, arbitration can become more expensive than litigation. D. It is not legally binding in any circumstance. Answer. C. If one party prolongs the dispute, arbitration can become more expensive than litigation. 1. How can parties pre-select arbitration as their dispute resolution method? A. By including an arbitration clause in the contract. B. By waiting until a dispute arises and then deciding. C. By consulting a court judge before signing the contract. D. By filing a lawsuit in advance. Answer. A. By including an arbitration clause in the contract. 2. What is mandatory binding arbitration? A. Arbitration that occurs only if both parties agree after the dispute arises. B. Arbitration required by a contract clause, where the arbitrator's decision is final and enforceable. C. Arbitration where the arbitrator provides only an advisory opinion. D. Arbitration that a party can ignore if they choose. Answer. B. Arbitration required by a contract clause, where the arbitrator's decision is final and enforceable. 3. When does voluntary binding arbitration occur? A. When both parties agree to arbitration before any disputes arise. B. When both parties agree to arbitration only after a dispute has already arisen. C. When arbitration is mandatory under the contract. D. When an arbitrator provides a non-binding recommendation. B. Arbitration that must be followed by a mandatory court trial. C. Arbitration where the decision is legally enforceable like a court ruling. D. Arbitration that is automatically required in all commercial contracts. Answer: A. Arbitration where the arbitrator gives an advisory opinion, but the parties are not required to follow it. 5. Which type of arbitration is the most commonly used? A. Non-binding arbitration. B. Voluntary binding arbitration. C. Binding arbitration. D. Arbitration with a jury. Answer: C. Binding arbitration. The correct answer is C. Binding arbitration. Explanation: binding arbitration is the most commonly used form because the decision, called an award, is final and legally enforceable, similar to a court judgment. Parties prefer it because it provides certainty, efficiency, and closure without going through lengthy court proceedings. Why not the others? A. Non-binding arbitration not final. Parties can still go to court, so it's less commonly relied upon. B. Voluntary binding arbitration. This is essentially a subset of binding arbitration, but the general term used is simply binding arbitration. D. Arbitration with a jury not typical. Arbitration is decided by an arbitrator, not a jury. If you're preparing for NPPE, this is a key concept. Binding arbitration equals final plus enforceable decision outside court. 6. What is a possible variation in arbitration clauses? A. The contract may allow one party to have the discretion to require arbitration. B. The contract can only include mandatory arbitration with no exceptions. C. Arbitration clauses are only valid if a court approves them before signing. D. Arbitration clauses must always allow non-binding arbitration. Answer: A. The contract may allow one party to have the discretion to require arbitration. Explain: the contract may allow one party to have the discretion to require arbitration. This means that the contract can be written in a way that gives one party the power to decide whether arbitration will be used to resolve a dispute. Section 14.3. Negotiation. 1. What is negotiation? A. A legal trial process with strict formal rules. B. A discussion aimed at resolving a dispute, usually through compromise. C. A scientific method of resolving conflicts. D. A court-ordered mediation session. Answer: B. A discussion aimed at resolving a dispute, usually through compromise. 2. What makes negotiation different from other dispute resolution methods? A. It follows a strict set of formal rules. B. It is based on laws and court rulings. C. It does not have a formal set of rules and varies from case to case. D. It always requires the presence of a third-party arbitrator. Answer: C. It does not have a formal set of rules and varies from case to case. 3. Why is negotiation considered more of an art than a science? A. Because it requires creative problem-solving and adaptability. B. Because it follows a fixed formula that guarantees success. C. Because it is based on mathematical calculations. D. Because it is strictly regulated by legal principles. Answer: A. Because it requires creative problem-solving and adaptability. 4. How can negotiating skills be improved? A. Only through formal legal training. B. Through studying techniques and gaining real-world experience. C. By memorizing a fixed set of negotiation rules. D. by avoiding any form of compromise. Answer: B. Through studying techniques and gaining real-world experience. 5. How can hiring a skilled negotiator help in the negotiation process? A. A skilled negotiator can identify important issues and assist in reaching a better settlement. B. A skilled negotiator ensures that a party wins the negotiation without compromise. C. A skilled negotiator eliminates the need for negotiation entirely. D. A skilled negotiator prevents the opposing party from speaking. Answer: A. A skilled negotiator can identify important issues and assist in reaching a better settlement. 6. What is one role of a skilled negotiator in a dispute? A. Helping parties recognize that some issues they believed were important may actually be secondary. B. Making sure that neither party compromises on their demands. C. Forcing the other party to accept unfair terms. D. Ignoring the key concerns of both parties. Answer: A. Helping parties recognize that some issues they believed were important may actually be secondary. Negotiated settlements. 1. What is one key advantage of a negotiated settlement over litigation or arbitration? A. The court decides the final outcome. B. The parties maintain control over the procedures. C. It is always legally binding. D. It guarantees a higher financial reward. Answer: B. The parties maintain control over the procedures. 2. Why is negotiation often preferred over litigation and arbitration? A. It is usually much less costly. B. It takes longer but ensures better results. C. It allows a judge to decide the outcome. D. It guarantees that one party will win completely. Answer: A. It is usually much less costly. 3. How does negotiation help reduce uncertainty? A. It ensures that the settlement amount is always higher than in litigation. B. Once a settlement is reached, the outcome is certain and avoids the risks of an uncertain trial verdict. C. It removes the possibility of future disputes. D. It allows both parties to present their case in court afterward. Answer: B. Once a settlement is reached, the outcome is certain and avoids the risks of an uncertain trial verdict. 4. Why might a party prefer to negotiate a quick $50,000 settlement rather than litigate a $100,000 claim with a 50% chance of success? A. Litigation always results in losing the case. B. The guaranteed $50,000 settlement avoids the risk and legal costs associated with litigation. C. Negotiation ensures the party receives the full $100,000 claim. D. A negotiated settlement allows the case to be reopened later. Answer: B. The guaranteed $50,000 settlement avoids the risk and legal costs associated with litigation. Technical. 5. What does it mean that negotiation is privileged in legal terms? A. It means only one party has the right to negotiate. B. It means negotiation is considered more important than other dispute resolution methods. C. It means that anything discussed in negotiations cannot be used as evidence in later court proceedings. D. It means that the negotiated settlement is always confidential. Answer: C. It means that anything discussed in negotiations cannot be used as evidence in later court proceedings. Technical. 6. What happens if negotiation fails to result in a settlement? A. The issues discussed during negotiation can be used as evidence in court. B. The negotiation process restarts automatically. C. Any information or discussions during negotiations remain privileged and cannot be used in court. D. The settlement amount is decided by a judge. Answer. C. Any information or discussions during negotiations remain privileged and cannot be used in court.